You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The enforcement role of the Federal Trade Commission in the privacy and data security landscape is best understood through patterns that have emerged across dozens of cases. While the FTC lacks a comprehensive privacy statute to administer, its Section 5 authority has proven adaptable enough to address misrepresentations, unreasonable data practices, and the unique sensitivities of health, children's, and biometric data. Over the years, settlement patterns reveal both the Commission's priorities and the practical lessons organizations must learn to avoid similar pitfalls. For learners, examining case studies illuminates not only what went wrong for specific companies, but also the standards that regulators expect across the marketplace. FTC enforcement is therefore both corrective and instructive. It punishes harmful practices while providing templates for compliance. Seeing these patterns helps learners anticipate risk areas and understand how theoretical principles translate into real-world accountability. Section 5 deception cases often begin with a company's privacy promises. When an organization claims to secure user data, limit third-party sharing, or honor opt-out choices, those statements become binding representations. If the company's actual practices diverge from its promises, the FTC frames that as deception. A classic example involves a platform promising not to share data without consent, only to provide advertisers or partners with extensive personal information. Deception can also arise when companies misstate the scope of encryption, exaggerate compliance certifications, or bury key details in unreadable disclosures. For learners, the key lesson is that transparency is not optional rhetoric. Once a company declares a privacy practice, it must follow through consistently or face enforcement. Misrepresentation, even by omission, becomes the root of liability under this theory. The unfairness prong of Section 5 targets unreasonable practices that cause harm regardless of whether promises were made. In data security, the FTC has repeatedly found that weak default passwords, lack of encryption, or absence of patching mechanisms create unreasonable risks. These risks are deemed substantial and not reasonably avoidable by consumers, who cannot reconfigure device firmware or audit cloud storage practices themselves. Importantly, the Commission weighs the benefits of a practice against its harms. When benefits are minimal but consumer exposure is high, the practice is unfair. For learners, unfairness demonstrates that compliance is not about box checking but about reasonableness and context. It acknowledges that perfect security is unattainable, but that basic safeguards are expected as a matter of law, not just good practice. Understanding how FTC investigations proceed is also essential. Cases often begin with a civil investigative demand, which compels documents, testimony, and data about company practices. Investigators may then conduct interviews, analyze marketing claims, and review technical safeguards before deciding whether to file a complaint. Complaints outline alleged violations, and in most cases are resolved through negotiated settlements rather than litigation. The final orders impose binding obligations enforceable in court. For learners, this life cycle underscores the seriousness of even preliminary inquiries. A civil investigative demand signals that regulators suspect a mismatch between promises and practices, and how a company responds can shape the outcome. The life cycle demonstrates due process, while also highlighting the efficiency of settlements in producing lasting reforms. Some of the most visible enforcement actions involve health and location data, reflecting heightened sensitivities in these areas. Health information, even when outside HIPAA's scope, carries risks of discrimination, stigma, or financial harm if misused. Location data, meanwhile, can reveal visits to sensitive places such as clinics, schools, or places of worship. The FTC has pursued companies that claimed anonymity while enabling re-identification or that failed to obtain meaningful consent before collecting such data. For learners, these cases highlight how sensitivity amplifies regulatory expectations. Data that reveals intimate aspects of a person's life must be handled with special care, and missteps are more likely to trigger enforcement. Sensitivity, while not always codified, becomes a guiding principle in the FTC's risk calculus. Children's privacy enforcement represents another cornerstone of FTC activity. Under COPPA, companies face explicit obligations for notice, consent, and minimization. Violations often result in civil penalties, reflecting the statute's strong deterrent posture. For instance, apps that collected children's data without parental consent have faced multi-million-dollar fines and long-term oversight. These cases illustrate how the FTC uses both Section 5 and COPPA authorities to protect vulnerable populations. For learners, they underscore that child privacy is treated as categorically important, with regulators willing to escalate penalties to emphasize its seriousness. In this area, compliance failures not only incur financial costs, but also reputational damage that can resonate with parents and educators for years. Data broker practices have also attracted FTC scrutiny, particularly because of their opacity. Brokers aggregate vast amounts of personal data from diverse sources and sell it to marketers, insurers, or other clients, often without consumer knowledge. When sensitive categories such as financial distress, health conditions, or precise geolocation are involved, the risks multiply. The Commission views the lack of transparency and meaningful control as unfair, particularly when individuals have no practical way to avoid inclusion in these databases. For learners, data broker cases illustrate how Section 5 adapts to evolving business models. Even in markets where consumers have no direct relationship with providers, regulators insist on fairness and honesty as baseline expectations. Advertising technology has been another focal point. Cross-context behavioral advertising, where companies track users across sites and apps to build detailed profiles, often occurs without clear disclosure or meaningful choice. The FTC has pursued cases where companies claimed data was anonymized, but in fact tied it to persistent identifiers. The mismatch between representations and practice constitutes deception, while the inability of consumers to reasonably avoid pervasive tracking may constitute unfairness. For learners, ad tech cases reveal how enforcement adapts to complex ecosystems. Even when practices are technologically sophisticated, the standards of transparency, consent, and reasonableness still apply. The key is not the complexity of the system but the fairness of its outcomes. Dark patterns have emerged as a modern enforcement theme. When interfaces are designed to nudge users toward disclosure, obscure opt-outs, or confuse parents into giving consent, the FTC frames these as deceptive. For example, a consent button, designed to look like part of a game rather than a legal decision, undermines true parental choice. Regulators view such practices not as clever design, but as manipulative conduct inconsistent with Section 5. For learners, dark pattern enforcement shows the convergence of design, psychology, and law. It highlights that compliance is not just about back-end systems, but also about front-end experiences that shape user decisions. Design choices carry legal consequences. The misuse of biometric and facial recognition data has also become an enforcement priority. Companies that collect and store biometric templates without adequate security or transparency risk both unfairness and deception findings. Representing that biometric data will be used solely for authentication, while repurposing it for marketing, constitutes deception. Failing to safeguard biometric identifiers is unfair, given the irreversible nature of harm if they are compromised. For learners, biometric cases illustrate how the FTC calibrates enforcement to new risks. The permanence of biometrics means regulators expect heightened diligence, and lapses are viewed as especially egregious. Enforcement against stalkerware and covert surveillance technologies further reflects the FTC's focus on consumer protection. Stalkerware allows individuals to monitor another person's device activity without their knowledge, often used in abusive relationships. The FTC has targeted developers and distributors of such tools, framing their products as inherently unfair. These cases highlight the ethical dimension of enforcement. Some technologies are so harmful that their very existence raises red flags. For learners, stalkerware enforcement shows that not all products are neutral tools designed for covert surveillance cross the line into practices regulators deem fundamentally exploitative. Internet of Things device security has also been a recurring theme. Products shipped with hard-coded passwords, insecure connections, or no-update mechanisms create widespread vulnerabilities. The FTC has pursued cases where such defaults placed consumers at risk, framing them as unfair practices. For learners, these cases reinforce the principle that security must be embedded at the design stage. In a world where consumers cannot patch firmware or reconfigure devices, responsibility lies squarely with manufacturers. The lesson is that reasonable defaults are not optional. They are part of the baseline duty under Section 5. Health app enforcement cases illustrate the overlap between privacy, security, and breach notification. Apps that promised confidentiality of health tracking data but failed to disclose breaches, or that shared sensitive data with advertisers without notice, have been subject to enforcement. These cases highlight the FTC's willingness to adapt Section 5 principles to new industries that fall outside HIPAA but still handle sensitive information. For learners, health app cases show that sectoral gaps in U.S. law do not mean regulatory vacuums. Instead, Section 5 operates as a catch-all, ensuring that basic standards of honesty and reasonableness apply across contexts. Finally, international providers have not escaped FTC jurisdiction. If a company targets U.S. consumers or engages in commerce that affects them, it falls under the Commission's authority regardless of its headquarters. This extraterritorial reach ensures that foreign companies cannot evade accountability by operating offshore. For learners, this illustrates how digital commerce erases geographic boundaries in enforcement. Companies serving global markets must assume that U.S. privacy standards may apply, even if their operations are based elsewhere. This global dimension reinforces the need for compliance frameworks that meet the highest common denominator across jurisdictions. Coordination with state attorneys general and other federal agencies rounds out the FTC's enforcement approach. Joint actions leverage resources, create consistency, and increase deterrent effect. For example, a deceptive health app may face simultaneous enforcement from the FTC, state regulators, and the Department of Justice. For learners, this demonstrates that enforcement is not siloed. Privacy and security failures attract a coalition of regulators, magnifying both the penalties and the reputational consequences. Understanding this coordination helps explain why companies often choose to settle rather than litigate. They face a united front of enforcement bodies determined to impose reforms. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The settlement structures used by the FTC are designed to both remedy past harms and prevent future violations. At the heart of these agreements is injunctive relief, which stops the unlawful practices and prohibits their recurrence. Orders often require companies to change how they collect, use, or share personal data, as well as to overhaul misleading disclosures. In addition, settlements impose conduct prohibitions that extend beyond the specific violations at issue, ensuring that organizations cannot simply repackage the same practices under different labels. For learners, these structures illustrate how enforcement is both backward-looking and forward-looking. Remedies address prior consumer harm, but are equally focused on reshaping corporate behavior to prevent recurrence. A consent order is not a narrow patch. It is a framework for cultural and operational change that may last decades. A common element in settlements is the requirement for companies to implement comprehensive privacy programs. These programs must include regular risk assessments, written policies, designated privacy officers, and oversight mechanisms. The FTC often specifies governance frameworks, mandating board-level awareness and officer accountability for compliance. For example, a company may be required to evaluate risks annually, document mitigation steps, and submit reports to the Commission. For learners, these programmatic requirements demonstrate how enforcement creates structure around privacy management. It is not enough to address issues informally. Compliance must be formalized, documented, and integrated into enterprise governance. This makes privacy not a side concern, but an embedded feature of organizational operations. Independent assessors or monitors are also a hallmark of FTC orders. These third-party professionals evaluate whether companies are adhering to settlement terms and provide periodic reports to regulators. In some cases, monitors have broad access to internal records, systems, and personnel, serving almost as an external auditor with legal authority. Their reports give regulators assurance that compliance is genuine, not merely promised. For learners, this requirement underscores the importance of independent oversight. It reflects skepticism that companies will self-police effectively without external checks. Independent assessors thus become both watchdogs and guides, enforcing accountability while helping companies stay aligned with best practices. Algorithmic disgorgement has emerged as a novel remedy in cases involving artificial intelligence or data misuse. When data is collected unlawfully, the FTC has required companies to delete not only the data itself, but also any algorithms or models derived from it. This ensures that ill-gotten information cannot provide lasting advantage. For example, if a company builds a recommendation engine using improperly collected facial images, both the images and the model may need to be discarded. For learners, algorithmic disgorgement illustrates how remedies evolve alongside technology. It reinforces that non-compliant data practices cannot serve as foundations for innovation. Compliance, therefore, must be built into data collection from the outset, not retrofitted after products are already deployed. Data retention limits are another consistent feature of settlements. Companies must establish schedules for deleting personal information once it is no longer necessary for the stated purpose. Orders often require documentation of retention policies and proof of implementation. This prevents the accumulation of sensitive archives that could become targets for misuse or breach. For learners, the focus on retention highlights a lifecycle approach to privacy. Data stewardship extends beyond collection and use. It includes disciplined disposal. Retention limits reinforce the principle of minimization, showing that holding on to information indefinitely is itself a risk and a compliance failure. Correcting notice and choice mechanisms is also central to settlements. Companies are often required to rewrite privacy policies, simplify consent interfaces, and provide redress to consumers who were misled. For example, operators may need to send corrective notices explaining how data was actually used and offering new opportunities to opt out. Some settlements include requirements for consumer refunds or credits where misleading practices had financial consequences. For learners, these remedies demonstrate the importance of clarity and transparency. Regulators view accurate notice and meaningful choice as the foundation of consumer trust, and settlements force companies to align their communications with their practices. Orders frequently mandate data minimization and purpose limitation commitments. Companies must limit collection to what is necessary, specify purposes clearly, and avoid using data for secondary objectives without new consent. These commitments are often memorialized in enforceable provisions that prevent broad, open-ended data use. For learners, these terms reflect core privacy principles that extend beyond statutory language. Minimization and purpose limitation provide structural boundaries that make data handling more predictable and defensible. In enforcement, they transform from aspirational values into binding obligations backed by the threat of penalties. Monetary components play a significant role in settlements. Civil penalties, restitution, and disgorgement of profits are used to deter violations and compensate consumers. The size of these monetary remedies varies with the scale of the misconduct, but high-profile cases often involve multi-million-dollar penalties. For learners, monetary remedies highlight the tangible costs of non-compliance. They make clear that violations are not just reputational risks but direct financial liabilities. In addition, they underscore the FTC's dual focus on both deterrence and redress. Money is extracted not only to punish but to restore consumer losses wherever possible. Orders also specify their duration, typically lasting 20 years. This long horizon reflects the FTC's recognition that cultural and operational change takes time. During this period, companies must submit regular reports, maintain detailed records, and certify compliance at prescribed intervals. These ongoing obligations create a compliance infrastructure that persists across leadership changes, mergers, or market shifts. For learners, the duration of orders underscores the seriousness of enforcement. A violation is not a one-time event. It reshapes a company's trajectory for decades. Long-term oversight ensures that reforms are institutionalized rather than temporary fixes. Violating an FTC order carries serious consequences. Companies that fail to comply with settlement provisions face enhanced penalties, including significant fines and additional oversight. In some cases, order violations have led to separate actions that imposed stricter requirements and higher costs. For learners, this illustrates that compliance is not optional once an order is in place. Failure to adhere is treated as defiance, escalating the severity of regulatory response. The principle here is escalation. Once trust is broken, regulators respond with stronger remedies to enforce accountability. Third-party oversight obligations are also common. Companies must ensure that vendors, contractors, and partners comply with the same standards imposed by the order. This may include audits, certifications, or contractual clauses requiring adherence. For learners, these obligations highlight the interconnectedness of modern ecosystems. Responsibility extends beyond a company's four walls, requiring diligence in managing the entire data supply chain. Settlements therefore drive improvements not only in direct practices, but also in vendor management and ecosystem governance. Security program requirements are often detailed in final orders. Companies must implement specific safeguards such as access controls, encryption, intrusion detection, and incident response protocols. These provisions are tailored to the risks associated with the business but generally reflect industry best practices. For learners, these security obligations illustrate how settlements codify expectations. They convert voluntary standards into binding requirements, ensuring that security is not a matter of discretion but of compliance. This approach turns common-sense practices into enforceable duties that carry legal weight. Board-level accountability has become increasingly important in FTC settlements. Officers or directors are often required to certify compliance personally, placing responsibility at the top of the organization. This shifts privacy and security from technical concerns to governance priorities. For learners, this provision emphasizes that accountability cannot be delegated away. Senior leaders must take ownership of compliance, ensuring that it is integrated into strategic decision-making. Board-level certifications signal to regulators, investors, and consumers that privacy and security are central to corporate governance, not peripheral concerns. The final dimension of FTC settlements is their role in shaping enterprise playbooks. Companies often treat past enforcement cases as cautionary tales, incorporating the lessons into compliance programs proactively. This lessons learned effect extends beyond the parties involved, influencing industry norms as organizations adjust to avoid similar scrutiny. For learners, this diffusion of enforcement outcomes highlights the FTC's broader impact. Each settlement becomes both a penalty for one company and a guide for many others. By studying these cases, organizations can design controls, governance structures, and cultural norms that align with regulatory expectations before enforcement becomes necessary. In conclusion, FTC enforcement reflects recurring theories of deception and unfairness, but achieves impact through structured remedies, long-term oversight, and cultural change mandates. Settlements are not mere punishments. They are blueprints for compliance that influence entire industries. By imposing programmatic obligations, independent oversight, and governance accountability, the FTC ensures that companies internalize privacy and security as enduring responsibilities. For learners, the key insight is that enforcement is both specific and systemic. It addresses individual violations while raising the baseline for market behavior, shaping how organizations approach consumer data for decades to come. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.